while you do not disregard the law, the letter of the law, you also craft your opinions and your remedies and your reliefs in a manner which would protect the ends of justice in a particular case. And there's a provision of the Indian Constitution which is very unique because it allows the court, the Supreme Court, to do complete justice to the facts of that particular case, and which we employ very, very regularly. I'll give you just one example. The Convention on the Elimination of All Forms of Discrimination against Women was one of the key components of the decision of the Indian Supreme Court when we dealt with the protection of women against sexual harassment in the workplace, which eventually led Parliament to enact a law following a judgment of our court. So you would find in a whole host of areas we have relied on international treaties, conventions to which India is a party, and sometimes even those to which India is not a party. The other area where we have relied on comparative jurisprudence, including jurisprudence from the UK, is judicial precedent, which is not in that sense international law strictly speaking, but we are adopting principles of judicial interpretation followed by other jurisdictions, including the UK, Australia, South Africa, countries in our own neighborhood, including Bangladesh and Nepal, the United States. So we look at a diverse set of international precedents, with a caveat though, which is that all precedent, particularly judicial precedent, is born out of the specific cultural traditions of each society.